By 2013, health privacy law in America was powerful and scattered. A statute from 1996, a privacy rule from 2000, rewritten in 2002, a security rule from 2003, and a 2009 law whose changes still lived in temporary interim regulations. Then, on January 25, 2013, the Department of Health and Human Services published one final rule that pulled it all together. Regulators called it Omnibus. One vehicle, carrying everything. This is the story of modern HIPAA Day. Health Tech Frontier. Here's what compliance looked like after high-tech. To know your obligations, you cross-referenced the original rules, the high-tech statute, and interim regulations layered on top, each amending the others. Practices needed lawyers just to know which page was current. The fix wasn't new policy so much as consolidation. Take 4 years of changes, resolve the public comments, and issue the final word. The Omnibus package bundled 4 final rules into a single document. 1. The high-tech changes to the privacy, security, and enforcement rules, made permanent. 2. Updates to enforcement itself. 3. The final breach notification rule, replacing the 2009 interim version. 4. Genetic privacy protections under GINA. Effective March 26, 2013. Compliance due September 23rd. One document, one deadline. The scattered era was over. High-tech had made business associates directly liable. The Omnibus rule finished the job. And went further. Subcontractors. If a vendor's vendor creates, receives, maintains, or transmits health information, they're on the hook too, all the way down the chain. Your data's chain of custody became a chain of liability. Existing contracts got a transition period into 2014. But the direction was set. There is no link in the chain where responsibility ends. The deepest change was almost philosophical. Under the 2009 interim rule, a leak was a breach only if it posed a significant risk of financial or reputational harm. And the entity that leaked your data judged that risk itself. The Omnibus rule flipped the presumption. Every impermissible use or disclosure is presumed to be a breach, unless the organization can demonstrate a low probability that your information was compromised. The burden of proof moved from the patient to the leaker. Doubt now favors disclosure. Patient rights got a digital upgrade. If your records are electronic, you now have the right to an electronic copy. No more paying for a paper printout of a database. And one detail for the history books. The rule set a limit on privacy itself. Protection now follows your records for 50 years after death. Half a century of confidentiality, even in the grave. Remember Episode 1, that quiet 1996 clause saying genetic information alone isn't a pre-existing condition? 17 years later, the Omnibus rule completed the thought. Genetic information is health information, fully protected. And most health plans are barred from using it for underwriting. Your DNA cannot price your coverage. An idea planted in 1996 finally had teeth. And the market got rules. Selling protected health information without your authorization, prohibited. Using your records for marketing pitches without permission, restricted, along with fundraising uses. The principle underneath it all: your health information has value, and the person who controls that value is supposed to be you. September 23, 2013. Modern HIPAA is in force. One consolidated framework covering providers, plans, vendors, and their vendors, with real penalties and public accountability. The structure that governs your medical records today is, in most respects, this one. But a decade later, that framework would be pulled into the most personal fight in American healthcare and lose a round in federal court. That's the next full story, 2024. Subscribe so you don't miss it. This has been Health Tech Frontier. Subscribe for the next chapter.